So I want to welcome everybody to the Contracts 101 course. John is an attorney, so he may or may not, I'm going to brace yourself, Karen. He may or may not practice the Socratic method. So if you've ever, no, you won't. That's good. Because those who've been in law school, that's a really, everyone is shaking in their boots with the Socratic method being drilled for an entire course on what do you know about contracts? So if we can move to the next slide, John, and we'll say the oath. I, Tiffany Joy Green, do solemnly swear to accept a lifelong obligation to hone my superhero powers and apply those superhero powers to the good of the people I serve. I will promote and add to the ongoing success of Empower People, its members, and the people, organizations, and communities it serves. I will help prepare the next generation of superheroes. I am driven to be a positive change agent for those I serve and interact with. And I would ask everybody to do superhero pose, which means you put your hands on your hips. You look up off into the distance. We'll do that for about 3 seconds. It will change your day. You will feel so powerful in a good way, ready to help others. There we go. So now, John, take the baton.
All right. I'm going to talk a little bit about contracts. So sort of entry level, I guess would say, or introduction to contracts, some things that I would hope people could get out of this. What are the elements of a contract? What should you be on the lookout for? What makes a contract legally binding? Sort of negotiating contracts and protecting yourself, your interests, and how you can mitigate risks as you're putting together or entering into contracts. And then some common contract pitfalls to be on the lookout for, try to avoid. So as Tiffany mentioned, my name's John Rabil. I own a law firm, Entrepreneur Legal Advisors, ELA. We are a firm that works with entrepreneurs, small businesses, typically as outside general counsel. And so we work with businesses that are worried they've got some liability they don't recognize, and they're scared about the risk that's putting on the company, and they're looking for an advisor who can help them sort of navigate all of that and help with things like contracts, employee issues as they move through their business life cycle. So I have drafted contracts and I've advised businesses on contracts. So this is right in the wheelhouse of the type of work that we do. All right. Fundamental elements of a contract. So essentially, all of these things need to be in place in order for you to have a valid contract. First one is an offer. So someone makes you an offer to sell you something in return for you to pay a certain price. That's the offer. And so a lot of times you don't see these steps broken down like this when you're entering into a contract with your business, right? You get a piece of paper and it includes all of these things in there. They're sort of all happening together a lot of time, unless you're negotiating big deals, that tends to be different. But the day-to-day and common contracts that businesses are using, sort of all of this comes at once, and it's all got to be there for it to happen. So acceptance, that's both sides of it. Signing the agreement, you've agreed to it, you know what it is, sign on the dotted line. Awareness, so you've got to be aware that there is a contract that's put in place and that you're entering into it. So they call it sort of like the meeting of the minds. You could be negotiating something, you still haven't quite come to what you think is a final version of the agreement or the contract. So if you can't establish awareness that you've both entered into it, then you may not actually have a contract yet. And so you're talking about, making sure you're not misrepresenting anything or the other party is misrepresenting something, and that you're all on the same page. There's a contract here. Consideration, so this is what's paid in return for whatever's provided in the contract. And it can be minimal. You don't have to have a lot of consideration. Obviously, it's often money, but it could be services in return or basically anything. I know a lot of times people will see contracts that say, in consideration for $1 or $10. That's making it clear that you've addressed that part of the contract and it's valid. So that's something to be aware of. Something has to be exchanged in return for something else. Capacity, not typically a huge issue a lot of times, especially in business, but you've got to be capable of entering into a contract. So typically what comes to mind there is a lot of times minors under 18 can't validly enter into a contract. And then, you got to have the mental capacity to enter into a contract as well in order for it to be valid. Again, that's not oftentimes an issue, but something to be aware of. And then legality. So you can't enter into a contract for anything that's illegal. So you couldn't contract with someone to steal $1 million. That wouldn't be valid, unfortunately. So these are the elements. So all of these things need to be in play in order for there to be a valid contract. So if you don't have one of these things taken care of, or something's been overlooked, there's an argument that there's not a contract that's been entered into, and therefore you'd have to make sure that you address whatever's missing in order to get to a valid contract. All right. So how do you know if your contract is legally binding? Essentially, it's you run through all of those things we just discussed. If you've got all of those elements there, then you typically have a legally binding contract. Where this gets a little bit tricky is oral contracts, which are valid in Virginia. And so it's not as clean, right? You don't have a piece of paper where you can point to most of the elements, or a chain that shows you've properly stepped through the contract process. And so it's difficult sometimes with oral contracts to be in alignment, difficult to show what was agreed to, let alone to show that there was actually a contract. So typically, if you've checked all the boxes from the previous slide with the elements, you don't have a big issue with contracts being legally binding. It's more of an issue on the oral side, where they are legal in Virginia, but it gets tricky showing what the terms were. Was there an actual contract? We talked about the sort of awareness, the meeting of the minds, that yes, this is a contract and these are the terms. Yeah, you can, I think, probably see how that could get difficult with oral contracts, trying to piece things together. Okay, a little about contract negotiation and terms that are important. So when it comes to contract negotiation, I think the starting point is to sort of fully understand what your goals are, and as much as you can, understand what the other party or individual is looking to get out of the contract. So who's looking to get what for what? And you want to get clear about the objectives, which are those, what's being delivered, what's the cost or the price. All of those things I think are very important, especially sort of as you plan to go into a contract negotiation, getting a handle on it from your side. And then I think you want to understand what's a must-have for you and what you could live without. So if you're going to get into a back and forth negotiation, it's important to understand, I can't live without X, Y, and Z, but some of these other things, I could do without, because you're likely going to have to compromise, which means each side's going to have to give up on something. So be aware of what you can't give up or don't want to give up. And something else along those lines is, if you do business with a lot of large companies, and I've seen this regularly with some of my clients, you aren't going to have a lot of negotiation room. You're typically going to have to take what they give you. Then what you want to make sure you do that in those cases is you have a great understanding of what is in the contract, because you'll at least have the option to walk away if there's something in there that's a deal breaker. So you want to pay attention to that. And then I think mentally, in terms of negotiation, putting yourself in a place where maybe walking away is on the table. Like, if you can't get one or two things that are important to you, then walk away and you look for an alternative. So those are sort of the things I would talk about in negotiation. I would if you're negotiating with someone or a company who's roughly, got equal stature to you, don't think that you have to be the one that gives up everything. Like I said, it should be a compromise. So it can be a give and take until you reach something that works out for both sides. So in terms of risk management, I think the first and sort of most straightforward part of it is make sure you read your contracts. A lot of the issues I see with contracts are people simply don't read them and they don't know what they've agreed to. So they know that they've agreed to get X service for Y price, but that's all they know. They don't understand anything else that's in there. What about confidentiality? What about terminating the contract? What if it's not working for you? Are you locked into this? So it's important to understand what you're getting into. You're not likely to have some back and forth negotiation for every contract you enter into, but it is important to understand what's in every contract you enter into. So first and foremost, easy, read it and understand what's in it. I think you'd want to look in particular at making sure there's a dispute resolution clause in there, especially when that's applicable for the contract. You can save yourself a lot of time and money and hassle if you spell out how disputes will be handled while everyone's happy and on the same page that you're going to work together. Things like arbitration, mediation, where disputes will be handled, for example, in Virginia, using Virginia law. Those things are important if something goes very wrong. I think you'd want to look at limitations on liability, either for you or for the other party, depending on the specifics of the agreement. But how can you cut down on your potential liability or damages you might have to pay if something goes wrong? That can be a good way to sort of at least cap your risk or your exposure if something gets out of hand. I think you'd want to look at termination and understand how that works. What if it's just not working out, but the other party's not breaching the contract? Do you want an option in there that lets you just terminate it for convenience? Because that's, like I said, it's just not working out. And so you want to move on to other options. So pay attention to termination and how and who the agreement can be terminated. I think it's important to regularly review contracts, laws, best practices change, contracts essentially go out of date. So staying on top of those things, getting a regular review to make sure you're still protecting yourself as much as you can, I think is an important risk mitigation strategy for businesses. And then I think another risk management sort of consideration is indemnification. And so what that does is it helps protect against losses or damages arising from the actions of a third party. So if a third party does something that causes damages, you may want the party you contracted with to be responsible for those, so you aren't responsible. So it's all ways to sort of pass off your risk or at least limit some of your exposure. And so important terms when it comes to contracts. We ran through some of them, but I'm going to touch on them again. But starting point is the parties and the roles. So make sure you get the right parties, who's involved in the contract, company or individual. Small businesses, a lot of times, operating sort of one-person businesses or 1.5-person businesses, they get trapped into entering into contracts in their individual name. That's something to pay attention to instead of their company name. And then, of course, you're starting to lose your limited liability protections of starting the company. So that's important. Get the parties correct and the roles correct. Making sure you spell out the scope of work if you're entering into a services contract. And I think don't be afraid to go into detail if you need to, but the scope of work needs to be flushed out so you understand either what you're getting or what you're going to provide. And payment terms are important. You're going to get paid $1,000, but when How are you splitting that up? Is it on completion or is it before the agreement starts? Those things are important. Oftentimes they're glossed over and just left at, I'll pay you $1,000 for X. I think you need to be a little more specific about when and how the payment's going to be made. Confidentiality. So every business has some confidential information. A lot of times when you're contracting with third parties, service providers, clients, customers, what have you, they're going to get access to some of your confidential information. It's important to protect that and make sure it maintains confidential. So you want to put in a confidentiality clause. And then on top of that, you probably want to address intellectual property in some settings. So every business has some trade secrets. Lots of businesses have some copyrighted material, even if they haven't registered it. Or you may be partnering with someone and they're getting some limited access to your brand, your logo, whatever the case may be. You really want to protect your intellectual property. Make sure that it remains yours and no one's going to get to use it in a way that you don't want them to. And along the same lines, I see a lot of agreements where companies are working together to create some end product. Could be a website, could be a paper, what have you. That's newly created intellectual property. So you're going to want to make sure to address who owns it, what they can do with it, how all that works. Because if you don't, you could end up in a situation that it's not ideal for you. And potentially you thought you had some ownership in something that you don't. And that becomes a nightmare or impossible to unravel down the road. Termination, we touched on a little bit. I think you want to make sure you include at least some information, language on how the agreement can be terminated. I think you want to address dispute resolution for the reasons we discussed. You can keep yourself out of court that way using other alternatives such as arbitration, mediation. Again, limitation on liability. If there's a way for you to get in there, some limitations on your liability, that's a great way to limit your risk in a term that could be very helpful to you if something does go wrong. Warranties and representations are another one to pay attention to, whether you're making them or the party you're contracting with is making them. It's essentially guarantees about how something will be provided or delivered. So you want to pay attention to those on your end to make sure you're not guaranteeing or promising something that you can't deliver. And on the other end, making sure that they're promising or guaranteeing that they will deliver what it is that you want, especially in terms of performance or products. And then there's some standard clauses, but I think they're equally important. You might have seen them, the entire agreement or severability clause. So you want to include those for a couple of reasons. The entire agreement essentially says that what's within the page is what you've agreed to. So nothing that you may have talked about before the contract was executed applies unless it's in there in writing. So you may have talked about a dozen different things leading up to the contract being signed, but only 6 of them made it into the actual contract. So they're the only ones that apply. And then severability essentially protects you from there being a clause in the contract that's not valid for some reason, and that leading to the entire contract being negated. So if the contract has a severability clause, and let's say one clause turns out to be unenforceable, or let's say something that you're not allowed by law to have in there, then just that clause can be taken out and the remaining contract is valid. So the entire contract's not invalid because of one clause. All right, a few common pitfalls when it comes to contracts. I think one is clearly not reading and understanding what you've agreed to. Possibly the biggest pitfall that I see. Another one is just watching out for ambiguous terms. For example, payment will be made on Wednesday, or goods will be delivered on Tuesday. Which Tuesday, where, what time? So watch out for those things. Lack of specifics and scope of work or deliverables. So, pay attention to make sure you're getting on paper what you want, what you expect to be delivered. I think not addressing termination is a pitfall. I see it all the time. People think that they can cancel a contract whenever they want just because it's not working out. Not necessarily true. You may have tied yourself into a 6-month or 12-month contract. Lots of contracts auto renew now for year-long periods. People don't realize it. They get stuck in a extra year that they wanted to avoid. It's not straightforward to get yourself out of that because you've obviously agreed to it in writing. So paying attention to that's important. Dispute resolution is a pitfall. You might want to pay attention to what the dispute resolution clause is, where disputes have to be handled if they come up. You know, if you're contracting with a company in California and everything's got to be handled in California, that's potentially a huge time and expense on you if a dispute comes up, a lot more expensive than it would be if, let's say, it was handled in Virginia where you're located. So don't get trapped into that. And then touched on trade secrets and intellectual property when we were talking about important terms. Not paying attention to that, especially these days with technology, and companies are creating significant amounts of intellectual property that they may or may not even realize in some cases. If you're not addressing that, you could lose what could be valuable assets to your company, and you don't want to do that. So you address it up front, watch out for that. So pay attention to what you're contracting for, and if you need to cover yourself with some intellectual property or trade secret issues along those lines. So a couple things to summarize. I've touched on oral contracts. I think, again, lots of businesses use them because, you know, doing handshake deals, nice, friendly way to do business, and they are valid. But if something goes wrong, you're going to have a hard time stringing together what the terms of the agreement were if you can prove that there actually was an agreement. I know a lot of times people talk about using email chains, but that's, or text chains even, still not necessarily that straightforward. There could have been a lot of back and forth. You could have not necessarily ever even said yes to anything. So I think a good practice would be to stay away from oral contracts. You know, every business doesn't need a 25-page contract. It could just be a half a page is appropriate for what you're trying to do, but something in writing that people are agreeing to and that you can point back to if something goes wrong. So that sort of leads right into my second point there. I think contracts are extremely important for businesses. It's a great way to protect yourself. It's a great way to mitigate risk. And there's some level of professionalism, I think, that comes with you're doing business. So, you know, I use contracts. It's, you know, people aren't likely to be surprised to have to sign a contract to work with you. So, one of the top ways I think small businesses, entrepreneurs can protect themselves from avoidable issues. And then in terms of traps, I think it's really watching out for oral contracts and not having something in writing. And then templates are a big issue that I see. And what I mean by templates is using like an online form generator or something like that to generate a generic contract for your business. They aren't specifically written for you. They don't know the specifics of your actual business. Yeah, maybe you're a consulting firm, but you probably have something or else going on that should be addressed in there. So just watch out for generic template contracts. Yeah, I've seen, for example, someone use a template that said their liability would be capped at $1 million, which is absurd. Way more than you would want it to be capped at, and that all their disputes would be handled in California. And this is a Virginia-based business, so they don't understand the specifics. They aren't written for your business, for what you are trying to accomplish. Be very careful using those. And yeah, so I think when you're looking at crafting your contracts, or entering into contracts, make sure that they're put together in a way that minimizes your risk, limits your liability where they can, and they really get you what you want. And all of those things sort of work together to push your company forward and allow you to sort of drive your mission home.
Thank you, John. I'm just gonna say goodbye to everybody on Facebook Live who's maybe watching or maybe watching it later. If you would like to be able to participate in the Q&A session that takes place immediately after the course, you can. It's simple. Just join Empower People for free, and the link to join is in the comments. So thank you for participating, and we'll see you again soon.